All right, let's get right into it. We're tackling a huge question that pretty much every homeowner thinks about at some point. Can you actually build that extension you're dreaming of without getting bogged down by the whole planning permission nightmare? Let's find out. You know the feeling, right? You've got this vision for a perfect new kitchen, or maybe an extra bedroom, but then reality hits. You start thinking about the planning applications, the cost, the stacks of paperwork, and just months and months of waiting. It feels like this giant wall of bureaucracy standing between you and the home you really want. And look, for a lot of people, this formal process is a real showstopper. It's seen as the single biggest, most complicated part of any project. And honestly, it can kill amazing ideas before they even get off the drawing board. But what if I told you there's another way? A sort of pre-approved path that lets you sidestep that whole application mess. The official name for it, right from the planning portal itself, is permitted development rights.
Now, these rights are the secret weapon to getting your project done without that planning headache. The best way to think about them is like a general nationwide permission that's been granted not by your local council, but by the government itself.
So, in a nutshell, permanent development rights are basically a set of rules that say, hey, if your project fits inside these specific boxes, you've already got the green light. It's kind of like an off-the-shelf approval for the most common projects, and it can save you an unbelievable amount of time, money, and stress. Okay, so it's not a total free-for-all, of course. This secret path is more like a very clearly marked trail, and to stay on it, you have to follow a list of really strict, absolutely non-negotiable conditions. And this is where we really need to pay attention, because knowing these rules is everything. If you get even one of these details wrong, your entire project could end up being unlawful. First up, the big one, the 50% rule. It's simple, really. All your extensions, sheds, outbuildings, you name it, cannot cover more than half of the land around your original house. Basically, it's there to make sure you don't pave over your entire garden. Okay, now for rear extensions, this is where it gets pretty interesting. If you have a detached house, you can usually build out by 4 meters. But with a much simpler process called prior approval, you can double that to a massive 8 meters. For any other kind of house, like a semi-detached or a terrace, the standard is 3 meters, but that can be pushed all the way to 6. There are a few other critical rules you've got to remember too. Height is a big one. Your extension can't be any taller than your current roof. Location is also key. You can't build anything in front of your house, and side extensions have their own set of rules about size and being single-story. And finally, a really important one. If you're building close to a neighbor's boundary within 2 meters, the eaves can't be higher than 3 meters. That's to make sure you're not blocking their light. Now, this is a really crucial warning. These rights don't apply everywhere. If you happen to live in what's called a designated area, think a conservation area or a national park, your rights are going to be much, much more restricted. Your council could also have something called an Article 4 direction in place, which just removes these rights completely. So you absolutely have to check first. Which, leads us to the next logical question. Even if you're pretty sure you've ticked all the boxes and followed all the rules, how do you prove it? How do you get that rock-solid certainty, especially when you go to sell your house and a buyer's lawyer starts asking a lot of pointed questions? Well, thankfully, there's an official way to get that peace of mind. The system has a specific tool designed to confirm, legally, that your project is all above board without needing that full planning permission. And this is it, the Lawful Development Certificate, or LDC. Honestly, this is the golden ticket. It's a formal legal document from your council that states, officially, that your project meets all the permitted development rules. Once you have this in your hands, you are safe from any kind of future enforcement action. And getting that protection is now more important than it has ever been, because there's been a huge change in the law. Before April 25th, 2024, councils had about 4 years to take action if a build was unlawful. But now, thanks to the new Leveling Up Act, that time limit has been extended to 10 years. The risk of not being 100% compliant has literally more than doubled overnight. So how do you get one? Well, applying for an LDC is a formal process, but it's way, way simpler than a full planning application. You're not trying to justify why you want to build it. You're just providing the evidence, your plans and drawings, to prove that it already fits the rules. Then, the council should give you a decision in about 8 weeks. So let's just quickly recap why going through this little bit of paperwork is so worth it. It's about so much more than just starting your build with a bit of confidence. Just remember, this certificate gives you absolute, undeniable legal proof that your work is lawful. It shields you from that brand new 10-year enforcement window, and it will make selling your house down the line infinitely easier. But most of all, it just gives you total peace of mind before a single brick gets laid.
So in the end, it really all comes down to this. If you're armed with the right knowledge of the rules and you get that lawful development certificate for security, your project can be a really exciting permitted development journey. But without it, you could be walking straight into a massive planning headache. The choice is yours.